with our moderator, Miss Anggita Lumbanraja. So without any further ado, Miss Anggita, the time is yours.
Thank you very much, Miss Denise. Nice to see you again. Okay, can you hear my voice clear? Okay, thank you very much. Good morning to our speaker, Dr. Tamara Joan Durasingham from Taylor's University. How are you, doctor?
Very good, Anggita. Thank you. And I hope you're well too.
Yes, I'm fine too. It is great pleasure to see you.
Pleasure is mine.
Okay. And hello and good morning to all fellow participants who are joining in this Zoom meeting and also watching live streaming on our YouTube channel. I hope you all have slept well last night and have a good energy to join us in this last session of Lex Proficia 2021. I am Anggita Joramia Lumadraja. I serve as Assistant Professor of Law in the Faculty of Law, Universitas Diponegoro. It's my pleasure to be a moderator for this last session of Lex Proficia 2021. Before we begin the virtual law class, I have a few notes for your information. This virtual law class starting from 8 until 9:45 a.m. in Semarang local time or 9 until 10:45 a.m. in Selangor time. So the presentation will be delivered by the speaker for a maximum of 45 minutes. Please note that there will be a question and answer section at the end of the presentation. If you have any questions or opinions for the speaker about the presentation, feel free to write down any questions that you may have in the chat column on the right side of the Zoom screen. You may send in your questions at any time throughout the presentation. Then moderator will compile the questions and address them at the end of the presentation. Please notice that these virtual law classes are recorded and also live streamed on our YouTube channel. Okay, before I invite the speaker to begin her presentation, I would like to introduce to you our speaker for today. Her name is Tamara Joan Durasingham, LLB, LLM, PhD. She got all of her title from the University of Malaya, Malaysia. And right now she is a tenure lecturer of law at Taylor's University, Malaysia, and also serves as the program director of PhD, philosophy of doctor in law at Taylor's University from 2019 until present. Before that, in 2014 until 2017, she served as Deputy Dean at Taylor's Law School. That's a brief introduction of our speaker for this morning. Dr. Tamara will present her presentation with the title Protection of Foreign Investment and Internationalizations of Contracts. She will talk about how the policy and regulation gives a protection for the investors, including the internationalization of the contract. And she will talk more about the investment with the spotlight issue regarding the expropriations of property. Now, without further ado, we will turn the time over to our speaker. Dr. Tamara, please begin your presentation.
Thank you very much, Anggita, for that kind introduction, and also to our MC, Dennis, if that's correct. Thank you very much. And to the university as well, Diponegoro. Thank you for inviting me. So my session today is basically to give you an understanding of the international law perspective of protection of investment, protection of foreign investment, and the internationalization of contracts. Now I see in the participant list some of the students being, I think, my students from
Yes.
Taylor's as well. So that's wonderful. And I hope I don't bore you.
Interrupting. Sorry, Tamara. Do you want to share your screen by yourself, or should
Yes,
we?
I will share my screen myself. Yeah.
Okay, thank you very much.
My students, please bear with me. Yeah.
Yes.
So let me just share my screen and let me just start. Okay. Okay. Let's go to slideshow. Okay. So basically what I'm going to do with you all is look at the international perspective, the public international law perspective, and not the private international law perspective. Okay. We are at a time when things are quite turbulent all around the world. And when I say quite, actually, I underestimate things. It's very turbulent around the world. So naturally, there would be fears, right? Fears in terms of investment. We have fears in terms of leaving our homes, let alone investing in anything overseas, right? So let's look at some of the issues that can arise when it comes to foreign investment. But before we start with that, I would like to ask, you all to think about this. What are the worries that come to your mind, when you want to invest in something? It may not be an investment outside of your country. It could be an investment even inside of your country, investing in some shares, or perhaps investing in some kind of mutual fund or insurance. What are the fears that come to your mind? Okay, now the fears that come to your mind would be the fears that come to the mind of any CEO, director of company, any entity that wants to invest in any part of the world. Okay, so when we look at law, whether it's international law, regional law, or local law, we begin with the individual, you yourself, and how would you deal with something in the domestic level, in the regional level, and in the international level. Actually, at the end of the day, it would be about the same, right? Because ideally, at the end of the day, the law that we subscribe to is based on our own right thinking and our own conscience, right? So basically, when we think about investment overseas, we might worry about things like, of course, currently it's the pandemic. We worry about natural disasters. Would we lose our investment? We worry about a brush in the law, a brush with the law, meaning that we may not know all the rules and regulations that we have to subscribe to in another country, in a foreign land. Especially if it's in a different region altogether, we may have our fears because we do not know the law. There is also a lack of control, right? There is a lack of control once the investment is outside of your country. There could be fears that there are things that you just cannot control. And anyway, we've come to realize that there is a lot in our lives that we cannot control, right? So losing money would be one of the main worries, right? When it comes to investment overseas. But then you have other problems as well. Losing friendships, losing business relationships, okay? War in the country, war in the state, that would be a fear as well, okay? Corruption in the country, are you able to deal with matters that arise? Do you understand how things work? Are you going to be bribed to do anything? Or do you have to give a bribe? Those are fears that will come to your mind as well. The culture within the state, okay? What is the culture? You might not know and understand. Limited ability to invest further, right? You might lose out and then you might not be able to invest in something better. Right, so there's so many things. Political instability or political issues that arise in the country, of course, is a big issue, is a big problem as well. It can be a big problem as well. Authoritarian rule, taking over of states can cause issues for your investment. And of course, the biggest issue now is the pandemic, right? So at the end of the day, it all boils down to trust. Can we trust that our investment will do well in a foreign country. And we're not looking at whether we are trusting another individual in the foreign country, because that comes under private international law. We are looking at whether we trust the governance of the state of another country so that your investment will be protected, right? So this, we are looking at this at a macro level and not a micro level, okay? So what we're going to look at specifically today is we are going to look at the issues that arise in terms of expropriation of property. Okay, and that is something that happens quite naturally in any state. A state has got sovereignty over its land mass, right? The state can do anything it wants when it comes to its land mass. So therefore, we would not know if property or our business would eventually be expropriated. What would these circumstances be like for us? What is the recourse? What is the remedy in terms of the law? Okay, so you have international standards in relation to expropriation of property. Okay, so we'll be looking at the international standards in relation to expropriation of property. And then we'll look at the internationalization of contracts. This is one way to protect your investment, to internationalize the contract, and we'll also be looking at other ways, other mechanisms of protecting your investment. Okay. Okay, so what does expropriation mean? What does expropriation mean? In the national terms or in domestic law, the term that is sometimes used is acquisition rather than expropriation. Okay, so expropriation denotes the taking of property. The taking of property by the state from a private individual or a private entity. Okay, so obviously when the state takes property that belongs to you, you are in Malaysia, you are in Indonesia, and you have invested in some property in, say, India. And what if the state takes over or expropriates the property? What is it that you would want to ask for? Obviously, at the end of the day, you would want that property to be yours still. But if you can't, what it is that you can get, it would be obviously compensation. Right? So the same way things work domestically, it would work internationally as well, right? So it can be an entire industry. It need not be just a piece of land. It can be an entire industry that is expropriated. And when an entire industry is expropriated, that would be deemed as nationalization, okay? So it's best regarded as nationalization when an entire industry has been expropriated by the state, right? It's not limited to taking of property only. It can be in so many different ways, okay? It could be also a punitive taxation that is imposed, local management instead of foreign management, permanent prohibition of sale. Those are all punitive measures that can sort of relate to expropriation. It's like as if it's expropriation of property, okay? So under international law, expropriation is lawful. It happens, right? Why does it happen? It happens because ultimately the state is sovereign and the state's sovereignty is meant to be respected. Okay, so it is not unlawful to expropriate, but how the expropriation takes place is the problem, right? It has to be done in the most proper way, in the legal manner. But the trouble here is that we are looking at international law. And what one country deems is the legal or the proper way may not be the same for another country. Okay, so there has to be sort of like a balance that is met or a compromise that is met, right? So when we look at expropriation of property and we look at international law per se as it stood in the 1960s, the notion is that when there is an expropriation of property, it must be for good reason. It must be for either public utility, security, or national interests. Okay? So if there is a good reason, and then there is appropriate compensation that is given, then it is considered valid, legitimate, lawful expropriation. And that is told to us in the General Assembly Resolution on Permanent Sovereignty over Natural Resources, General Assembly Resolution 1803. And because international law is very Eurocentric, international law was developed in Europe, right, first, and then only spread to across the globe. Now, this particular view on expropriation is the favored view. This particular view of expropriation could be deemed as customary international law. Okay. The other thing that is mentioned in this particular within this view of the developed states is that the expropriation obviously cannot be discriminatory. And that can take place as well, right? Discriminatory expropriation because of something that the state has done, that you're unhappy with, so you discriminate one state against the rest, that would be completely illegal in the eyes of the developed states, right? So this is the understanding of the developed states, but then you also have developing states which sort of get the short end of the stick if you're going to employ General Assembly Resolution 1803, okay? So the developing states have a different view, and their view is encapsulated in the Declaration on the Establishment of the New International Economic Order and the Charter of Economic Rights and Duties of the State. Okay, so this is in 1974. 60s, you had a stricter view. 1974, you have a more nation-centered view, right? Nation-centered view, meaning that at the end of the day, expropriation has to be determined by national law, not international law, by national law, because the country itself would understand the scheme of things, what's happening within the country. The country itself would know how to compensate, right? International law can't really step in to do that for the country because the international perspective may be very different. So the developing states favor this view where expropriation is based on national law. It's not based on the General Assembly Resolution 1803. Okay, now both affirm the legality of expropriation and go on to provide that appropriateness of compensation is to be judged solely by reference of national law. Okay, so the declaration and the charter basically tells you that national law applies for compensation. It doesn't say anything about non-discrimination. It doesn't say anything about public purpose. So we can see the distinction here. Okay, which means that why the expropriation took place need not be revealed, right? But as long as there is compensation based on what the state can afford, that should be sufficient. So obviously, if you're an investor, you might not be very happy with this particular way of looking at things. You would be, you would prefer the international law standard, which is provided in General Assembly Resolution 1803. I hope you all are still with me. I know it's a Friday morning and this is a bit heavy, okay? But anyway, let's go on to a public purpose, okay? Public purpose. And when we look at public purpose, generally, of course, like I said earlier on, certain cases had decided that public purpose is important. But then there were cases post-70s, Liamco's case in 1981, that stipulated that public utility principle is not a necessary requisite for the legality of nationalization. So these changes were based on the 1974 Charter and Declaration. Okay, so it really depends on which country it is, what the situation is, and what standard ought to be applied for that particular country. Okay. Now, in the case of Shaheen Shein Ibrahim in Iran, it was about compensation, basically, and it was decided that the tribunal there declined to decide whether the appropriation was lawful or unlawful, concentrating instead on the measure of compensation, which means that this is in favor of developing states perspective. It simply means that the legality of the expropriation is not an issue. What is an issue is compensation, and that is it. Okay, meaning that a state would be entitled to expropriate. There's nothing illegal about it. As long as it goes by, of course, its national laws, there's nothing illegal about it. But the compensation should be appropriate. Okay, so this is how certain decisions have been made over the years with regards to expropriation. So the cases that sort of favor the developing states' way of looking at things served the developing states well, right? But the issue arises as to whether that would be the best mechanism to employ, of course, right? So the developed states have got a mechanism of coming up with compensation, okay? So when we look at compensation, we have to make sure that the compensation that is given to the investor is adequate, right? So the developed states have come up with this PAE formula, and this is known as the Hull formula. The formula basically is that the compensation that is given, it must be prompt, it must be adequate, and it must be effective, okay? Prompt, adequate, effective compensation, right? That was the idea that was mooted, and this is a good mechanism, okay? It is employed in a lot of countries. It is employed within the developed nations, right? Now, the 1962 resolution supports this international sort of standard, okay? So this is an international minimum standard, and it reflects customary international law to a certain extent, right? So like I said earlier on, as long as the compensation is prompt, it's adequate, it's effective, that's good enough, right? But this is again the developed states view. The developing states view is that never mind prompt, adequate, effective, we will go by the national treatment standard. We won't go by international treatment standard or international minimum standard, okay? So what is the national treatment standard? Basically compensation that a national would get, a citizen would get, a foreign investor would get that same level of compensation. Why? Because that is what the country can afford, right? So it depends on things like what is appropriate compensation. It depends on things like the economic viability of the state. The state is probably expropriating property simply because it doesn't have the money. It needs to expropriate the property, okay? The state is probably in some kind of economic trouble, and that is why it is expropriating the property, okay? So this standard depends on economic viability. It depends on the importance of the expropriated property. Also, it depends on the benefits that the foreign investor has already received from the property. If you have already received a lot of benefit from the property, then, you know, perhaps at this point of time, if the compensation is lesser, it is somewhat acceptable, okay? So again, you can see this divide. Okay, you saw this divide in terms of expropriation being lawful or unlawful. And you see this divide in terms of compensation, right? Between the capital importing states and the capital exporting states. Okay, so let's move on. Right, so early cases did not use this Hull formula of prompt, adequate, effective compensation, right? In fact, if you look at cases like Aminoil's case in the 1980s, if you notice the cases in the 1980s seem to favor the developing states approach, depending on which state was in court, basically, depending on the state that was taking the matter to court. So when it came to Aminol's case, it was decided that, the best thing to do is just look at the facts and not the theories. Okay, the theories are good in paper, but then at the end of the day, it's based on what the country can afford, right? So that is based on the facts, right? But the case of Texaco basically referred to appropriate compensation, good compensation, appropriate compensation as a rule of customary international law. So you have these conflicting sort of cases or decisions. Now, the World Bank guidelines basically favor the developed states approach, where the expropriation itself has to be fair, it has to be in good faith for public purpose, right? And the compensation must be based on prompt, adequate, effective compensation. So the PAE, that's what the World Bank guidelines basically stipulates. Now, a case closer to home, the case of AMCO and Indonesia. If you have not heard of this case, perhaps you might want to look it up. It's about expropriation of a hotel as well as a shop and office complex in Indonesia. Basically, at this point of time, it was in the 1980s that this happened, right? And what was decided there was, what is full compensation? It was decided in the case. Basically, the full compensation, but is awarded including the damnum emergens and the lucrum cessans. Now, what is the damnum emergens and the lucrum cessans? That is the loss suffered, the damnum emergens. The lucrum cessans would be the expected profits. Okay, ideally, that would be what should be given to the party. But that does not happen in all cases, but that would be the ideal scenario. Okay. Now, sometimes when you have nationalization, and I've mentioned nationalization to you earlier, the idea of full compensation will be undermined. Okay. Why will it be undermined? Because, it's an entire industry that is being nationalized. Obviously, the state may not be able to afford a lot of money for it. May not be able to afford paying for the whole industry. And therefore, the amount may be undermined in terms of compensation, right? So at the end of the day, we look at the fair market value, right? The amount the willing buyer would have paid the seller for the share of a going concern, ignoring expropriation completely. That would be the right standard, but that is not the standard that necessarily is employed. Okay, so we would favor looking at the value of the property pre-expropriation, because the value of the property, the moment there is expropriation, the value will drop, right? So you would want to get compensation based on pre-expropriation. And that would be the international law standard as well, but it is not necessarily subscribed in all circumstances, right? In the case of EMOCO, it was decided that compensation for lost profits is only available where there is wrongful expropriation. If there is no wrongful expropriation, then that is, the profits will not be received. Okay, loss of profits will not be attained as well. Now, the question arises, what is unlawful expropriation? Because you have to prove unlawful expropriation before you can get loss of future profits. Okay, so unlawful expropriation would be basically based on the General Assembly Resolution of 1961, right? Where either the expropriation was done without public utility, no public purpose, or no compensation was even talked about, or the particular expropriation was discriminatory, right? So in these circumstances, it would be considered as unlawful expropriation. Of course, there's another circumstance as well, where there is a breach of a treaty, right? If there is a breach of a treaty, obviously then the expropriation that violates the convention, violates the treaty would be unlawful as well. Okay, so those are the circumstances in which you have an unlawful expropriation. And when you have an unlawful expropriation, then perhaps your compensation will include loss of future profits. Okay, but that is the developed states standard. It's not necessarily the standard across the border. Developing states, of course, may have a different standard when it comes to this. Okay. So as law students, I don't know about you all. I'm not a fan of mathematics, but some of you all may be fans of mathematics. But when it comes to expropriation and determining the compensation, the other thing that's important is the maths. How do you actually do it? How do you actually determine the compensation that is going to be awarded, right? So there are different ways of doing it. The one that is favored is the going concern method. But if you look at the discounted cash flow method, what it does is it calculates compensation by reference to the value of the enterprise at the point of expropriation, okay, in terms of its projected revenues over the period for which the investment was expected to last, minus the outflow, okay? So that would be the discounted cash method. It is kind of speculative because you're looking at projections, so it may not be the best approach. But then you have the converse of it. The converse of it is the net book value method. It's different, it's the opposite of it because you're just looking at the paper. Reference is made to the paper value of the assets, just looking at the paper. So in that sense, it's not the best because it excludes things like goodwill, know-how, experience. It minimizes the value of the property or the industry as a going concern, right? So it may not be the best method either. So the best method is the going concern method, which includes the tangible and intangible values of the property and the liabilities of the similar kind are deducted. It can include loss of future profits as well. Okay, so these are the methods that are employed. The most popular one is the going concern method to determine what kind of compensation you will receive. Supposing there's expropriation of your property or a taking over of a business that belongs to you in a foreign country. Okay. So like I said earlier on, by right, the value should be the value pre-expropriation, but sometimes that doesn't happen. Like in the case of Shaheen Shein Ibrahim, that didn't happen. The value of the property was based on on the value during the Islamic Revolution. The compensation at that point of time was somewhat low. Okay, so a state could also have lump sum settlements. And when you have a lump sum settlement, then the compensation may be quite low as well, right? So these are in terms of compensation. When it comes to discriminatory actions, of course, that would be unlawful as well, okay? Discriminatory types of nationalization is not something that is considered as lawful. Okay, now let's go on to another aspect. Okay, so we're coming to the crux of the matter, basically. How do you protect your investment, right? And one of the ways of protecting investments is an internationalization of the contract. Because when you internationalize a contract, the contract comes within the purview of international law. So if it comes between the purview of international law, then your customary international law would probably apply. The General Assembly Resolution of 1608 will probably apply in your circumstance because it's an internationalized contract. Again, it really depends on the circumstances, but this is something that can be done to protect the investment. Now, what is an internationalized contract? First of all, the first type of situation that brings you to the realm of international law. Okay, before we go into internationalization, we look at the realm of international law. So from a domestic level, your matter is going to be uplifted to an international level. Okay, why is it a good thing for it to be uplifted? It's because then you are governed by the treaties. You're no longer governed solely by domestic law. You see, your whole situation is governed by international treaties. And international treaties would obviously, probably, I would say, provide greater safeguards for the individual, right? It's meant to provide greater safeguards for the individual. So therefore, if something goes wrong at a domestic level, okay, you were not given the avenue to leverage on the due process of law, then the matter can go into the international plane. Okay, that's one. Another is where the contractual right has been expropriated. It's possible that it becomes an international law matter. But the clear-cut situation is when there is an internationalization of a contract. Okay, and what does that actually mean? The internationalization of a contract. The case that gives you an explanation of that is the case of Texaco, right? So looking at the case of Texaco, it specifically gives you 3 situations, okay, where your contract can be considered to be internationalized, right? First of all, is when there is reference to a system of law that is other than your own system of law. Okay? Reference to a system of law that is other than your own. So basically, it's stipulated there in the judgment. Secondly, if there is a clause in the contract that says that the matter will be sent or settled by international arbitration, okay? That is the other circumstance. And thirdly is when there is an international development agreement, meaning to say that your investment is not only about, buying and selling something, you're also perhaps developing the state, developing pockets of the land, for example. Say, for example, if you're from Indonesia, you're coming into Malaysia, to invest in palm oil plantation. And what you do is you develop the land, you create schools, you build roads, all of that as well. Then it becomes an international development agreement. Okay, so these are the circumstances in which you have an internationalized contract. So if you put in international law into your contract, it becomes internationalized. If you put in a clause that says international arbitration, it becomes internationalized. Or if you say it's an international long-term international development agreement, it becomes internationalized as well. So it lifts the contract from the domestic domain into the international domain. Okay. So what's the good thing about that? Well, it places it within the purview of international law, right? There could be a clause that says that the contract will never be terminated. That's called a stabilization clause. And those stabilization clauses are provided in international contracts. But obviously, there's no such thing as a contract that can never be terminated, right? It's just that the measure of compensation, if there is a termination, will be based on international standards. Okay, that would be the more proper view to this. Okay, the stabilization clause itself gives effect to an increased award of compensation if there is a case of expropriation, right? So you may have what is known as a stabilization clause in your international contract or internationalized contract, okay? So I'm nearing the end. If y'all are still with me, I'm towards the end already. Now, apart from internationalization of contract, what else can you do? To protect your investment, you also can ensure that there is no Calvo clause in your contract. Now, what is a Calvo clause? A Calvo clause basically means that all the matters must be submitted to national court. Any dispute must be submitted to domestic court and not to an international arbitration tribunal or anything like that. Okay, so the moment you do that, then you're closing yourself to a particular domestic setting, which may not be ideal. So you always must ensure that there is no Calvo clause in the contract. If you can input in your contract prompt, adequate, effective compensation, then you're bringing in, the World Bank guideline as well as the General Assembly Resolution 1608. That would be a good thing to do as well. Okay, you can seek registration in the state. If you want to register your business in the state, that might be a good thing to do. Enter into a treaty with the state. No doubt this is not something that is so easy to do. It's between state and state, but this is also one of the things that is done, entering into a treaty or bringing the matter within the regime of ICID, International Convention for the Settlement of Investment Disputes. Okay, you could do that as well. So these are some of the things that you could do to your contract to safeguard your contract, to make sure that if anything goes wrong in your investment, at least some kind of international law will be able to protect you. Some level of international law will be able to protect the investment. I'm not saying that international law is perfect, of course, but the trouble is that we may not understand how the domestic systems work around the globe, and therefore international system at least is universal. It's something that is understood worldwide. It would be easier. Okay. So very quickly, Angita, do I still have time? I don't think I do, right?
Of course, you still have time. Perhaps
Pardon?
2 or 3 minutes. You have still time, about 2 or 3 minutes.
Okay, okay. Thank you very much, Angita. So here, this is just a question that I want to pose to you all for you all to think about. Okay. Basically here, this person by the name of Julia lived in and traded in Moreland. It's a totalitarian state for 20 years. Recently, she's been arrested, detained, and her property has been expropriated, right? So the issue here is about the expropriation of her property, okay? And this is something which is common. Whether you are a Moreland national or not, it's common. So she was expelled from Moreland, okay? And then she returned to Kaplan. She is a national of Kaplan. A bilateral agreement exists between Kaplan and Moreland for the compulsory settlement of disputes between them. So advise Julia as to the status of her expropriated property. Would she be able to get her property back? Would anybody like to try?
Is there anyone of the participants want to answer?
Anybody want to try? You can always try.
Try to guess.
Maybe I know my students, I'll call them. No, I won't torture. I will not torture anyone because I subscribe to international law rules on human rights.
Okay, you may raise hands by pressing button on your Zoom menu bar, so you can answer. Try your best to guess the answer. What is from Taylor's University? Is there any one of you who want to try to answer your lecture question, professor question?
Just whether or not, just tell me whether she can get her property back, that's all. Yes or no? Just
yes or no. You only answer that simple answer, yes or no. Explanation you can add or not is up to you. You just answer yes or not. Hello?
Nobody wants to try. Okay, that's okay. Because it's Friday morning, I understand. Somebody raised. Okay, wonderful.
From Iqbal, from National University of Malaysia. The time is
Hello.
yours.
Okay, thank you. Hello, doctor. My name is Iqbal, and I think the answer is yes.
Can get the property back.
Yes.
Okay, very good. Why do you say that, Iqbal?
Because I think because of the bilateral agreement.
Because of a bilateral agreement. Okay, that's interesting. Thank you very much for that answer. Yeah, that's very interesting because you brought up the bilateral agreement between the two. Okay, but when we look at the bilateral agreement, Iqbal, it is on the compulsory settlement of disputes between them, right? It is not necessarily on how they would deal with expropriated property. Okay, so whether or not she will get her property back is actually yes or no. At the end of the day, it depends on Moreland, right? It depends on Moreland. More likely than not, rather than get her property back, she would probably be able to get some form of compensation, right? And because this is an authoritarian state, it probably does not subscribe to international law rules the same way as the European states would. So therefore, probably the compensation will be based on the laws of Moreland. So the compensation might be low, we do not know. Compensation can be high also, who knows? But chances are the compensation will be lower than the international standard. Okay, so yes, it depends on the circumstance. She could get a property back depending on Moreland, what kind of state it is. But if she doesn't get a property back, then she will get some form of compensation, which may not be a very high amount of compensation. Got it, Iqbal?
Yes, yes. Thank you, Doctor.
You're welcome. Which semester are you at, Iqbal?
I'm currently at semester 4.
Oh, already year two.
Just finished my year 2.
Wonderful. So only 2 more years, right? 2 more years to go.
Yes.
Okay. I am also alumni of UKM. So we are from the same university. I got my PhD from UKM. Yeah. Thank you for that question. I mean, for that answer. It's my question. Thank you for that answer. Okay. So that's it from me, Anggita.
Okay. Thank you very much, Dr. Tamara, for providing this very interesting presentation. And thank you very much for Iqbal for your nice try to answer the questions from our speaker. Now we come to the question and answer session. Now I have seen the chat column is there no any questions from the participants, and we are still waiting for you. There's no late time to deliver your questions, and we are still waiting for you. Is there any questions, or perhaps you want to ask your question directly? You can pressing the raise hand button right now.
You can ask general questions as well, like generally, right? You need not be specifically on the topic. If you're not sure on the topic, maybe generally on international law, anything.
Yeah, perhaps is there any problems, or there is an issue that brings out from your major in your college or your campus? You can bring out the questions from your major to our speaker. Perhaps about international law, and then about the contract, and then the investment protections, anything.
Can I ask them questions?
Of course, perhaps there is your students in here. You can ask directly to them. You can maybe mention their name from the
I don't know whether I want to do that to my students.
Okay, over general. Okay,
but
over
maybe,
all the participants.
Yeah. I would like to ask maybe, what do you think about the whole situation of learning now and the COVID-19 pandemic? How are you all finding it? Anybody can answer.
Okay, is there anyone to give your opinions regarding your situations during the pandemic? If you have any obstacles of your learning process, or perhaps how to understand the majors, then with conventional way or in an online way, whether the choice that you want to choose. Please answer your question, the question of the parties for the from the speaker. Sorry. Is there anyone to answer? Iqbal, perhaps? Do you want and deliver your opinion? uh, you can share your experience during the pandemic learning.
I'm gonna. Can I share my?
Sure. Danish, is it from UKM?
Yes. I'm very interested with your presentation. Very eye opening, and I even myself, when you were giving lecture, I'm very interested in this international investment law, and
Thank
also, yeah, to share my experience because I'm like first year student, and I finished my first year with online class fully. So it's very stressful because I never step into the camp. So yeah, and also the difficulty is that when I want to ask question, we have the limit of the raise hand and the connection problem. So it's very difficult to actually ask a very long question exactly. Yeah, I think that was very limiting in sharing session. Yeah, that's all.
Thank you. Thank you for sharing. That is a very good insight for us, so we know what to do. We can understand how the students face. You must realize that we are all facing this together because for you, it's the first time going through online the whole semester. For us lecturers also, it was the first time last year, March. Of course, now it's better for us, but last year, March 2020 onwards, it has been online. It has been very different and very, challenging. It has been challenging, right? Yeah, but one of the things you can do is if you cannot ask your question then and there to your lecturer, one of the things that my students do is they do email me. And when I have the chance, I will reply. It may not be immediately because there are a lot of emails that come in, but give your lecturer a chance. Just like you, we like to know, that you are actually learning, right? We like to know, we like to engage with you, just like how you would like to engage with us, right? So it's nice, when we get emails or when we get questions, we are quite happy because we know then, okay, the student is paying attention, the student understands, or the student is following, that's important to us because now we cannot see you. In class, we could see you. So we know if you're frowning, you're not happy, you think it's rubbish, we know, but now we don't know. So it's very difficult for your lecturers to gauge. So if you can't give us the question then and there, then the option is email. The option is also during tutorial session, you can ask the question because the group is smaller, easier for you to ask the question. Okay, I hope I have sort of answered or given you some tips, Danish.
Okay, thank you very much
You're
for
welcome.
the insightful information for me. You're sharing, Dr. Tamara, and of course from Dennis. Okay, we
Thank
have
you.
one questions from our participants from Undip, from Eliza. Eliza, do you want to deliver your question by yourself, or should I read your questions to our speaker?
Hi, Eliza.
Yes, Prof. Good morning.
Good morning.
I want to ask about the existence of investment from foreign countries. It is important for a country, but there are some countries that make regulations regarding foreign investment is quite difficult. So my question is, what I want, if The investment is important for the countries, why the regulation made quite difficult for the foreign parties. Thank you, Prof.
Okay, thank you for that question, Eliza. It's an interesting question. You see, at the end of the day, the country does welcome foreign investment, right? Every country wants foreign investment because at least money is coming in from elsewhere. Every country wants that. But at the same time, countries do worry about, they have to sort of balance out what's happening within their country and what's happening in other countries as well. They need to sort of make sure that there is no monopoly, there is no unguarded investment in your own state, in your own country. Because once there are foreign investors, the possibility of foreign investors taking over an entire industry is there. And when that happens, the moment a privilege is given or the moment a right is given to invest, to grow, to develop, to progress, sometimes it can be difficult to remove that investment. When the country is ready to do things on its own, difficult to get this foreign investor out of the picture, right? Difficult. So the country has to be very careful in balancing out, in determining what it is that it wants in terms of foreign investment. So that's why the rules and regulations will not be easy to go by. It will not be that way because that balance has to be met. Okay, there cannot be a monopoly that arises because of the foreign investment. They don't want foreigners to come in and take over things in the country. That happens in countries, isn't it? And then the locals are affected by it. So these are the issues that come up and states have to think about it. That is why regulations are quite tedious, especially now everything is digital. It makes things even harder. You think it's easier. You think it's easier because everything is just crossing in this way. Nobody has to go mechanically anywhere, physically anywhere. But it's actually harder because when you invest and when you negotiate, when you talk to a person, actually you don't know who the person is. You don't know the other side so well. Whereas when you invest in a way that you travel to the state, you meet the people involved in the investment, all that, it becomes different. Then it becomes a little bit more, that element of good faith, that element of trust is built. At the end of the day, any business has to be based on trust as well. Okay, so digitalization makes things actually harder because that element of trust cannot be really seen. So regulations have to become tighter, So this is the thing that you have to take note of, Eliza. It's obviously not easy, but it's not easy because the country also needs to be protected. I hope I've answered your question. Eliza?
Eliza?
Yes, thank you, Prof. For
You're
the
welcome.
explanation.
Eliza, is it Eliza or is it Eliza?
It's Eliza, Prof,
Eliza.
actually.
Okay, sorry, Eliza.
Okay, thank you very much, Dr. Tamara, for your
You're
explanation. So the regulation should protect and also accommodate public interest and then personal protections, of course, inside of them to accommodate to avoid any risk of the harmfulness or wrongful act. So the regulation has to be tightened up, and then meanwhile, our speakers have already mentioned about these digitalizations. Perhaps we expected more simple, more easier for us to do anything, but if in fact we met so many complicated problems surrounded us. Okay, we have another question from Dennis. Okay, Dennis, you can read your or ask your questions directly to our speaker.
Good evening, Prof. I'm Danish from GAM. In case of exploration of state over local company, where there are quite a large number of majority shareholder or foreign investor, does the compensation given by state will be the same between the local and foreign investor? And can the foreign investor ask for it to be on the international standard? Thank you.
That's a very interesting question. So you're saying that basically you have shareholders from local as well as foreigner. But when it comes to a company, it really depends on where the company is registered. So the nationality of the company becomes important, not the nationality of the shareholders. You know, so if the company's nationality is a foreign nationality, then the demands can be greater. But if the company is a domestic company, then the demands may not be greater. You cannot use international law because everything is local. You understand? So it really depends not on the shareholders, it depends on the registration seat of the company. Have I answered your question, Danish?
Yes, sir. Yes, Prof.
Okay.
Okay, so it depends on the company, not for the
On the
shareholders
shareholders.
individual. Okay. Thank you very much for the question, Dennis. And is there any questions for the other participants? Perhaps we still have enough time to receive your question. If there's no more questions, we will wrap our morning. Oh, there
is one, Daphne. I know
Daphne.
Daphne.
Yes, your student. Daphne.
Yes.
Hi, Miss.
Question.
Hello. So
Hi,
nice.
Dr. Tamara.
So nice to hear your voice, Daphne.
Yeah. So nice to hear your voice too, Miss. Like so long already. 2 cents
Yes.
past. Yeah. Miss, I have a question. Because this area of law is not in our really like our module. So I have a question. Like, do you think that the government has a big role in this field? Like, as in the investment from the public international law perspective? Yeah, that's my question.
Whether the government has a big role? Yes, yes. It does have a big role. Ministry of International Trade. This is the domain of the Ministry of International Trade, right? So their role is to ensure that all trade is done in the, in a way that the citizens can leverage on it, as well as, foreign investors also can get a good end of the deal. So this is done, basically the rules, the regulations, the governance of it is at ministry level would be with the Ministry of International Trade, Ministry of International Trade. So it is, an important area for the government. International trade is obviously part of government. It's part of the agenda for development of the country. When we look at international trade, we are also looking at letting in foreign workers, foreign labor into the country. So when it comes to trade, it's not only in terms of trade or sale of goods or sale of services, it's also the movement of labor, right? So all this has to be governed by the state. So it's not only international trade, it's also the human resource ministry. It is also, a few ministries have to sort of work together to ensure that these investments are handled in the best way possible. Okay, Daphne, I hope I've answered your question.
Yes, definitely, Miss. This okay. We can see that currently it's COVID-19 pandemic, and then the government usually allocate the resources on maybe other field, like maybe the health and maybe the SOPs, and then maybe they do not really put much focus on like investment and stuff like that. So that was my kind of not a concern, but really a doubt, I guess. Yeah, because due to this pandemic.
Yeah, the focus now would be the pandemic, but there could be investment that is connected to healthcare. There could be investment that is, covers the area of the pandemic as well. So there is leveraging of those types of investments now within ASEAN, especially, to make sure there's enough medication, there's enough supply of vaccines. That's all trade at the end of the day. So it's of course, it has got the humanitarian component to it, but it also has got a bit of the investment component to it as well, right? So even though maybe certain investments are dormant at the moment, like say investments in relation to civil aviation is dormant at the moment, but other investments are probably flourishing. Okay.
Yes. Okay.
Perhaps like health equipment and then medical equipments like that.
Yeah, movement of doctors, movement of nurses, all that can actually take place, eventually may take place at an international level.
This time. Okay. Thank you very much for the nice questions from Daphne from Telus University. Is there any one of you want to ask another questions, perhaps? Oh, from Hanifa from Undip. Hanifa, you want to ask your questions to our speaker? You can turn on your microphone.
So, good morning, Professor Tamara.
Good morning, Hanifa.
My name is Hanifa Krisnarianto from Diponegoro University. I would like to ask, is that possible that the company will not get the compensation because of expropriation? And what should they do? Thank you, Prof.
Well, unfortunately, it is possible. It can happen that, there could be disputes, investment disputes that are long-standing about companies not getting the compensation that they deserve. There are possibilities of that. Now, what they can do is that, like I've said earlier on, lift it to the domain of international law. It cannot be a domestic thing, because if it's a domestic investment, that means you're using only domestic law, and then the land is expropriated, then you only have to rely on the domestic law. You might not get any remedy. But if it's lifted into the international law, that means the matter goes into international arbitration, or the matter goes to the ICJ, it becomes state on state. There is more of a possibility of bringing the matter, getting some form of compensation, because then the international law will apply. So that is why when you sign a contract, you have to make sure that the contract doesn't necessarily only employ domestic law. Or better still, if you don't want to bring in the whole gamut of international law, you bring in the domestic law of your country, because then the sort of safeguards, are there. Certain rules within your country, rather than only solely the country of the state of investment, Yeah, so those are the things that can be done. So it's very important how the contract is drafted, to make sure that, this kind of thing doesn't happen. But it can, especially war-torn countries, you can't do anything. Frustration of contracts, you can't do anything. Sometimes the losses lay where they fall. When the losses lay where they fall, what can you do? You might not be able to get your compensation sometimes. It can happen that way.
Okay, thank you, Prof.
Does it
You're
answer
welcome.
your question, Hanifa?
Yeah, it's clear. Thank you, Prof.
You're welcome.
Dr. Tamara, our conversation getting more interesting right now.
Getting more challenging for me. Now it's like I'm in an exam viva like that. PhD viva.
Okay, all the things from the begin. Okay, Iqbal, you can ask your questions.
Oh, hello, am I audible?
Yes, Iqbal.
Okay. Prof, Doctor, my question is, as you all know, that Malaysia has already finished in March 2021, the government or the Yang di-Pertuan Agong had promulgate an emergency right, and under the federal constitution, the Yang di-Pertuan Agong can promulgate ordinance if needed. So under the federal constitution, the government via Yang di-Pertuan Agong had promulgate an ordinance called Emergency Essential Powers Ordinance 2021. And under the ordinance, it said that the government can how to say can have the power to take temporary possession of land, building, or movable property, right? So, in your opinion, does this ordinance conform with the principle of expropriation and the international law standard? That's my
Yes, this ordinance basically goes against international law rules. And that's why an emergency declaration and an emergency ordinance that comes with it, even though it's not utilized in that way, it doesn't, maybe the government will not take over any land, maybe it will not happen, right? But an emergency is always, the effects of an emergency will be felt, right? Post-emergency setting. There will be countries or there will be persons who will be hesitant to invest in a country that declares emergency too often, That is something that is, it's a sign of instability, which is not good for investment, right? So, well, it's, it's a good thing that the emergency is lifted. The emergency is lifted, that's a good thing. At this point of time, I'm not sure whether the emergency is lifted. but of course, the situation is such, looking at the pandemic, any other country who would want to invest would consider that if at any point of time an emergency takes place, the most justified point would be during a pandemic, So there is a justification for the emergency, right? So, but that doesn't make it sort of aligned with the ideal notions of international law. It doesn't, right? So it's not ideal, right? But it was needed, but it's not ideal. And therefore, investments will be affected if emergencies are prolonged. It will affect investment into a given country, including Malaysia. Any country that has this kind of ordinance and it's used, if it's there, it's dormant, it's okay, If it's used too often, then it can deter investment. Yeah. I hope I've answered your question, Iqbal.
Yes. Thank you, Doctor.
And thank you for informing me of that ordinance. We learn from each other.
Yes. Okay, thank you very much for your question, Iqbal, and for the speaker. Thank you very much for your explanations. And then, is there anyone you have a question, perhaps? You want to deliver it to our speaker?
How many universities are participating in this?
It's about four universities.
That's
from
wonderful.
Australia and Malaysia. Taylor
Wonderful.
University, and then the National University of Malaysia, Flinders University, and Canberra.
Wonderful.
So we are very okay. We have another questions from Dennis. Dennis.
Hello, bro. Again.
Yes, Danish.
Okay.
Yes.
Okay, I want to ask about in the case of Texaco versus Libya, where the part where you say that the contract within class of the national development agreement were long-term assistance to a state in the area of essential economic activity. But what if the industry itself monopolized by foreign investor?
Okay, so yeah. So here is where was it Eliza who spoke about regulations being quite, Eliza spoke about regulations being quite tight? Yeah, it's not so easy to get an international development agreement, right, between countries. So again, like I said, the underlying theme for any investment is that element of trust between the states, you know. So international development agreements can come up, but then whether or not it's something that will necessarily go as planned, right? The trajectory of the investment is determined by the state, the host state, the state in which the investment is taking place, right? The host state and not the investing state, you know, the trajectory of it. So if at all the international development agreement is going well and good, but there could be circumstances where the international development agreement is, can cause a monopoly to exist, then of course the state has to think about the next steps. Ultimately, the state is sovereign, Danish. Ultimately, the state is sovereign. So any point of time you want to expropriate, you want to take over, you can, because you're sovereign, right? But obviously they don't want to do that as well, just very hastily, you know? So, so these kinds of agreements also are really, the countries have to think it through before it's done. It also makes a particular company, the company is coming in to invest as well as to develop, it makes that company a subject of international law. And that becomes a very different situation altogether. Subject of international law means you're bound by international law rules. You know, you're no longer just an object of international law. You become a subject just like any other state. It is possible when there is an international development agreement. So then it again gets lifted into the domain of international law. So it has to be done in the proper manner as well. Got it, Danish?
Yes, Prof.
Okay, thank you.
Okay,
Kelly has a question.
Yeah.
Kelly,
Kelly,
hi. Apa
Kelly.
khabar, Kelly?
Hi, Miss.
Hi, it's good to see that you're here as well. Long
Yeah.
time since I've seen you.
Miss, I have a question. When a state wish to expropriate a property, and is there any other ways that the owner of the property could refuse to do so since the state is sovereign?
Yeah, that is a bit difficult. That's a bit tricky. Because even for, just take this at our local level, okay, Kelly, we take it at a local level, because everything that from up, international level, actually you cascade it down, the same thing happens at the local level, okay? So we look at it locally, Kelly. If the government wants to take over your property, can the government do that or not? What does the federal constitution say? Yes. Correct, because the government is it's sovereign. It can, and all the land belongs to the crown. All the land belongs to the king. It's sovereign, right? So the same way under international law, the investors can't really do much because sovereignty of state is there. The concept is paramount. The concept is paramount. Sovereignty of state. It's above any form of investment. You know, so therefore, you can't really stop it. The most you can do is negotiate. That's the most you can do. Try to negotiate, try to buy time, stall the expropriation process, you know, that's the most you can do. But you can't really stop it. This is when my point of view is that when you have a face-to-face relationship with the other side, things are better, all right? So even if the whole circumstance is digitalized, it's fine, but there must be some level of interaction. Then negotiations can take place more effectively. So in that kind of circumstance, it really boils down to how you negotiate and how you buy time for the expropriation. But you may not necessarily be able to get to sort of negate it completely, yeah? Eventually, it may happen. So you prepare for it, you know? Yeah. But countries, states don't want to expropriate also because they know that countries will, investments will be pulling out. They'll pull out. Companies will call out their investments, right? States don't want to necessarily expropriate. They usually expropriate when they don't really have a choice. Okay.
Okay, thank you, Miss.
You're welcome.
Okay, thank you very much, Kelly, for your nice question, and thank you very much for the presentation from Dr. Tamara. Is there any question from the other participants? You can raise your hand, or if there is another, we will close our session. Okay. I think there's no more questions from the participants. We will close the session, and then for Dr. Tamara, could you please to conclude your presentation and give some brief conclusion for the participants? Time is yours.
Okay. Okay, thank you. Thank you all for getting up so early to listen to what I had to say about expropriation. I'm very amazed by your dedication towards the law. Okay, so I hope you've learned something. You may not, it's sometimes very difficult to learn everything at a summer course because there's so much to learn. There's so many different aspects that you're learning. But there will be key points from every speaker. There will be key points that you can take home, that you can remember from this summer course. And I hope that there are some key points from my course, from my lecture as well. And one of the things that maybe a key point that I want you to take home is, if you can't remember anything else, just remember that any business venture, any investment should be built on trust. Just remember that, okay? And I wish you all the very best in your discourse with the law and your practice of the law. I wish you all the very best. And I know that all of y'all, if you all are law students, will be wonderful lawyers one day. And if you're non-law students, you will be great in whatever career you are going to involve yourself in. So thank you very much for this opportunity. Thank you, Anggita. Thank you, Pulung.
Thank you very much, Dr. Laura. Yes, Pulung is your student in
not students,
Malaysia.
Colleagues.
He is already told to me about you supervise him when he studied in UKM.
Short while, yeah.
Okay. Very well. Thank you very much for your conclusions, Dr. Tamara. So to all the participants, remember the fundamental principle of the bounding institutional contract is about trust principle, has already mentioned from our speakers. Okay, the conclusion that wraps our morning, and then now we come to the end of this class. And once again, I would like to say thank you very much for our speaker, Dr. Tamara Joan Singham from Telos University. We very enjoy every minute of your presentation, and happily there will be another chance to receive your lecture on our campus again, and we will continue our conversation about the investment.
Thank you
very much. Okay, I would like to highly appreciate to all the participants of your great enthusiasm this morning. You have already woke up early in the morning and want to ask very interesting questions. We would not have a good time without your active participations. Thank you very much for making time to join us here this morning. I hope our conversation this morning will give the insightful knowledge and inspiration to everyone in here. Thank you very much for your attention. Stay safe and keep healthy for everyone. Good morning. I'm now going to pass the things off to Miss Dennis. Dennis, it's your turn.
All right, thank you so much, Miss Anggita, and of course, Dr. Tamara. That was a very insightful and exciting topic that you guys just talked about, and that's it for today's session. But in 30 minutes from now at 10 a.m. local Semarang time, there will be a closing ceremony for Lex Proficia 2021. So I hope you guys stay tuned and stay safe. See you guys soon.
Hello, Dr. Calvo.